Good morning, everybody, or actually good afternoon. It's 12:05. Okay. Today we are making a presentation on some migration updates that is relevant to the TISMIT and increased salaries, and just shed some lights on Far North Queensland DAMA changes, what is coming up, and their scheduled salary threshold changes. First of all, I would like to introduce our company. This is actually a Hungarian accent for everybody, okay, if you would like to know my accent. And the company, we started in 1998, so we are in business for quite some times now, and we have been through many changes and many challenges, just as keep coming, okay, so we just need to adjust to them. And what we do is we're not just doing migration services, or we're not just providing migration services, but also we have a very experienced employment law division, also property law division, and some commercial law division as well. Today, I invited our senior principal lawyer, Darren Taylor, to provide some information and insight of what a corporation requires to provide the best employment contract with some of the nitty-gritty clauses, what is required to have a successful migration application. Most of you probably have that already, but there are some new changes coming out all the time from the Fair Work as well. So we thought that would be very beneficial for you. Just why we are in business really is something very important and we are very proud of. We came up, many, many years ago, and our logo is also representing that we're offering a way forward to our clients in all division and really changing people's life. Okay, so as you can see in this slide, we're talking about the overarching company of No Borders Law Group, NB Law, NB Commercial, NB Employment, NB Migration, and NB Property Law. Next slide, please. Thank you. Okay, what I'm going to talk about today is, as I said, the overarching topic is, the new changes, what's are coming out on 1st of July in regards to the TISMIT, and some changes into the Far North Queensland DAMA process. Key changes from 1st of July, improve impact on employers and visa applicants, industries most affected, and strategic actions before the deadline, FNQ DAMA, and legal checklist for sponsorship. Beside that, the last couple of slides will talk about, the employment contracts, and then we'll talk more about the employment law regarding, what we require for a successful visa application from the employment law point of view. First of all, next slide, please. First, I would like to talk about, the current situation, and I assume you all aware of what is the current TISMIT. And this TISMIT is actually the threshold for the salary level. And the TISMIT is currently $73,150. Under the DAMA principle, this is reduced by 10%. So calculation is about $68,000 or $67,000, something in the vicinity of that. And this is the minimum salary what an employer has to pay for the an employer has to pay to the employee when they're sponsoring. That is also crucial, and I may mention this here, that it's not just the minimum threshold what the employer required to be paid to the employee, but also this threshold must meet the minimum salary requirement, the market rate, okay? So the market rate is, if the market rate would be below the $73,150, say in Brisbane, then you cannot pay the $73,150 because that is an inflated salary in the eye of the department. So if you have an employee, and this is just a little hint as well, if you have an employee in certain occupation, say someone is a mechanical fabricator or fitter, then the salary may be $72,000. That's the market rate. So how you can do $73,150 or above, you actually can nominate that person as a team leader or as a supervisor, and then the salary can be adjusted accordingly. So you meet the basic threshold under immigration law, and also you would meet the market rate. Okay, so just remember these two main components, market salary and also minimum threshold. All right. So the current threshold under the core skilled occupation list is 73,100, as I mentioned. Under the specialist skilled list, okay, which is a higher level skilled occupation, it's currently $135,000. And of course, all these salaries subject to plus superannuation, okay? So this is just the base salary. So currently it's $135,000 plus superannuation. We had a client, where the person was employed as a chiropractor, and the chiropractor, for example, has to be paid this specially skilled occupation because the occupation is just on a specially skilled occupation list. So the person had to earn $135,000 plus superannuation as a registered chiropractor. And the market rate is, and that was the good thing, is anyway about $123,000, $130,000. So if a person has a couple of years experience, then certainly the person can earn $135,000. For example, for whatever reason, and I just mentioned this briefly because it came to my desk, personal assistant, for example, which is mainly high-level administration, but a personal assistant is only available on a specially skilled occupation. So a personal assistant to a CEO has to earn about $135,000 plus superannuation. So this is just, presenting you some examples, where a specially skilled occupation is required and they have to be paid this salary. Certainly, the market rate has to meet with this as well, as I said before. Now, as I mentioned at the beginning, the DAMA is actually, the FNQ DAMA requires or allowing a concession of 10%. And that would reduce the salary because that is a regional area. So that is pretty much acceptable in that space. May I have the next slide, please? Okay, so on this slide, we explain again what is the current salary level. And as I said, and just as I see, and you can see on this slide as well, we have the 482 and the 186. The 186 can be direct entry or transitional. The salary level is the same, all right? So the TISMIT is relevant to both visa process. So the 482 and 186 currently 73,150. The increased salary from 1st of July, it will be $76,515. Okay, so that's about a $3,000 rise, which is probably about, if we look at it, about 5% increase. Now, the inflation rate is not really 5%. Not that I know of. So I think the department is a little bit running ahead of themselves, but that's nothing unusual with them. But that's going to be the new salary level from 1st of July. In regards to the specially skilled occupation, currently, as I said, $135,000. From 1st of July, it will be $441,210. Okay. So why is this important to know and why we wanted to talk about this? Because there are some clients who get caught up in the change of salary and change of salary level. And the visa applicant had to leave the country, the visa application or the nomination. Actually, if you remember, the salary level and the employment contract is actually required not for the visa application, but for the nomination. And the nomination is nominating the occupation what the person will be working in. So this can affect the employer's activities, but in turn, this can affect the visa applicant eligibility. So just an example, last year was also a salary increase from 68,000, whatever it was, the threshold, around 68,300 or something in that nature. The salary was increased again 1st of July to the $73,150. And one of our clients, who was not our client at that time, was affected because the representative who represented them in May conducted a labor market testing with the salary level what was current before 1st of July. While the Department of Home Affairs have made the announcement way before 1st of July. So the labor market testing actually should have been done under the new pay scale. Okay? So the representative ought to know that the salary would be over $73,000. Labor market testing has to be carried out for 28 days. So if the labor market testing started early June, that would be finishing early July. So the new salary level for the nomination would have been at the higher level. So what is that required then? To lodge a new labor market testing or conduct a new labor market testing with a new salary level. All right? Because with the old salary, the nomination could not have been lodged and could not have been processed. Otherwise, they would refuse it. So in turn, the visa applicant visa was expiring. The visa applicant had to go overseas. So it has caused a lot of issues. All right. So this is why we thought it's important that we share this with you now, because it's early May. So if anybody is considering to employ someone in the next 2-3 months, the labor market testing should be done from now on, taken into account the new salary level. To avoid any discrepancy at any time, we always recommend to use a salary level as a scale, okay? So from $70,000 to $85,000, okay? Or if you have other employees who are employed for $68,000, you start the salary level at 67, and you say, see, between $67,000 and $80,000. Because if you give this scale of salary, then you cannot be said, oh, you advertised for $73,000. Okay, so that's a little hint for you when you do your labor market testing for a nomination to advertise the position with a scale of salary. Okay, and certainly for a higher level of occupation, which requires $141,000 or above, again, you can say $135,000 to $145,000. So that's in a nutshell about the current and the future changes for the TISME. Now, also, this level of salary is applicable to the 186 direct entry or transitional 186. Now, when you do the transitional 186 application for an employee, that person may be granted a visa 2 years ago or 1 year ago under the old salary level, and you need to make sure that that person receives that salary. But the new employment contract for the permanent residency always has to reflect the new salary level. Okay, the person's salary would not change, or you don't require to increase the salary of an employee with a visa who holds the visa or who have the visa, the 482. You don't require to increase the salary. If you increase the salary of an employee, you increase the salary under Australian industrial, or you might review the performance. This person, really doing a great job, so you can increase the salary. But it's not required under the migration rule. So if the salary increases from 1st of July, you do not require to change the employment contract and increase the salary until the visa is valid. Or if you lodge a new application later on, then you would require to implement the new salary level. All right. Next slide, please. Okay. So as I mentioned that before, I just listed this, what's happening with existing visa holders, what's happening with new nominations, and the compliance. I mean, the compliance is only relevant when you applying for a new visa for the applicant or a new nomination. Actually, as an employer, you're not applying for a visa in a sense, you're applying for a new nomination. And the new nomination always must reflect the new salary. And the compliance is important that during the period of the nomination, you have paid the correct salary with the superannuation. Now, if a person goes on unpaid leave, then you don't pay a salary to that person for that period. However, that unpaid leave period cannot be taken into account for a 2-year employment, because during unpaid leave, the person is actually not employed or not work. I mean, maybe employed but not working and not earning a salary. So therefore, that person cannot say end of the 2 years, hey, I am eligible for the permanent residency. No, you're not, because you may have taken 1 month unpaid leave because you had to go to visit your family. So the nomination cannot proceed. For a permanent residency, a new 482 nomination has to be applied for, and a new visa has to be lodged to facilitate the visa applicants' 2-year employment requirement under the transitional stream for the 186 visa process. All right. Thank you. Next slide, please. Okay, we just did a little bit of checking, but I think any salary increase can affect any industry, except industry where the minimum salary level is anyway $80,000-$90,000. And I think some spaces in construction and different trades, people are already earning above $70,000-$80,000, depends on the position, certainly. This is seriously affecting the aged care industry because, in aged care and other support services, the salary is below this TSMIT level, but for aged care and disability support services, there is a labor agreement available where I believe the salary level is around $68,000. So you still can offer positions for, some of those employees of yours. Agriculture and retail can affect it. But in retail, really, we only have a position as a retail manager. And in a regional area, we have a retail supervisor. But as I mentioned, under the DAMA in a regional area, you would have the concession of 10% of the salary level, okay? And affects regional employers, generally speaking, because regional employers coming under the same system as the 482. Now, regional employer coming under usually the 482 or the 494 visa stream. The 494 is a regional sponsorship, but unfortunately, the salary level, if it's not a DAMA area, and in Queensland, we only have DAMA in Townsville and Cairns or Far North Queensland, it's not coming under that salary level, but it's coming under the normal salary level. So it doesn't matter, it's a regional area, the salary still has to be paid according to the minimum, what's going to be $76,150 or $500. All right. Next slide, please. Okay. Now, in regards to the North Queensland DAMA or FNQ DAMA and the Townsville DAMA, we have mostly updated information for FNQ DAMA. The Townsville area DAMA hasn't published anything. This is just recently implemented, probably about 2 years ago. So, and as you're aware of any regional labor agreement, which the DAMA is a labor agreement done by the relevant regional body, in this instance, the regional council, the Chambers of Commerce in Queensland and the Chambers of Commerce in Townsville. So they have a labor agreement with the Department of Home Affairs. Now, every labor agreement is valid for 5 years. So this is the reason why Townsville doesn't make any changes at the moment, or if they do, it's mostly an internal changes. But the FNQ DAMA would come up for renewal, and I think the new renewal is implementing. It's going to be valid, or they extended by another 2 years until 2027. So there is no major changes for the requirement under the Far North Queensland DAMA application. And roughly what I have read is about 50 occupations that will be added to the list. They have quite substantial occupation list in both spaces. Townsville area DAMA is a little bit more restrictive. I think that's the right expression. It's taking a little bit longer. You cannot communicate that easily with them. But the FNQ DAMA, Far North Queensland DAMA, is an amazing process. And, you can communicate with their representative. And roughly takes about a week to get the approval. So as I said, 50 occupation will be added, and also they will keep the 10% concession regarding the salary level. So in those areas, if you have, facilities and regional offices or branches, you can negotiate the salary down to 68,000 something. Okay, I haven't calculated the 10%, so that's my bad. Okay, but everybody can calculate the 10% discount. And as you all know, the endorsement timing. Okay, so it's just the endorsement has to be approved before 1st of July. Okay, so if you're lodging an application after 1st of July, so if you lodge the application and the endorsement hasn't come through, then you may need to be aware of that it's going to be knocked back after 1st of July because it's not the proper salary that what was nominated. So just be mindful of all this, okay? And as I said, you may advertise, because the main thing is the labor market testing, you may advertise with a scale of salaries, okay? Next slide, please. Okay. Review, yes. I, really gone through all the nitty-gritty stuff, what you need to be mindful of when you coming up for these changes. Your employment contract can be reviewed, but it's not affecting the changes if the 482 visa is granted for 2 years or 3 years, you are able to continue paying the same salary to the employee. But also, when you nominating someone because they are meeting your requirement for employment, or this person has already been working with you, it is very important that you're placing everything strategically for the future employment of that person, okay? And they discussing, salary increase. As you all know, as an employer, you have the Skilling of Australia fund, what you have to pay. We don't hear anything about changes to Skilling Australia fund. So keep finger crossed, they're not going to increase that fee. I'm sure there will be a fee increase in regards to nomination fee or visa application charge as they did last year. I mean, last year they did a very substantial pay rise, almost, or I think it was actually more than double the fee for the short-term visa process, or I think maybe it came out in November, not exactly in July. So you can, prepare yourself and taking all this into consideration and just prepare yourself. As I said, this is the perfect time if you would like to nominate someone in July or August, that you start the labor market testing and using the correct salary level. Next slide, please. Okay. Yeah, again, all the slides explains what, I explained before. Again, early lodgement. And if you would like to avoid the pay rise, okay, or minimize your exposure to the minimum salary level changes, then you should have the labor market testing now and lodge the nomination before 1st of July, because the salary level won't affect the approved nomination. So, and also applications which has been lodged before 1st of July, they're not subject to the changes because, of course, the application has been lodged before 1st of July. So that's very important, okay? Now, I think, next slide, please. Yes, I think my presentation is, ending now. So has anybody has any question, or Mao, are we doing the question at the end, or can I answer some questions now?
There's only one question at the moment. So
Yes,
it's from Tony.
yes.
Can employer and employee in mutual agreement change the agreed salary reduced following the nomination approval grant under the SSIT? New employment agreement signed with updated salary.
Um, can you read it again, please?
Can employer and employee in mutual agreement change the agreed salary reduced following the nomination approval grant under the SSIT?
No. A salary level cannot be reduced once the nomination is approved. So if the nomination hasn't been launched, but the labor market testing has been done with the relevant salary, the salary cannot be changed. Okay? So you only can change the salary during the process if you haven't lodged the nomination, but you prepared the documentation. And the person who you're nominating is not subject to labor market testing. Quite a few countries, or, people who are holding certain passports, they not requiring, or the employer does not require labor market testing. So in that case, amongst one another, you can change the employment contract. That's not a problem. Under DAMA and under the nomination, you cannot reduce the salary. You have to pay the employer what you have agreed to. All right. Now, if there is a financial implication because of the company has maybe some restructuring or some financial issues, maybe, you know, you might say to the employee, hey, can we just have a reduced hours and I unable to pay your current salary, or can we have, an unpaid leave, to overcome some difficulties. But really the salary cannot be reduced. And minimum salary, what is the threshold, the TISMIT, that has to be paid to the applicant or to the visa holder during the life of the 482 visa. Have I answered the questions, Tony? Excellent. Thank you, Tony. Any other questions, please? Mao, no more questions?
No more questions. We can move on to Darren, and after Darren, we can do a Q&A session afterwards.
Thank you
Thank you.
so much. All right, everybody, may I introduce you to Darren Taylor? As I said, he's a principal lawyer in our employment law division, and he will talk to you about sponsorship obligation from an employment point of view. Darren, thank you.
Thank you, Agnes.
Thank you.
That was so insightful, Agnes. I must say there were so many useful tips and so many different varieties there that I think people need to take on board. And I particularly took on board the importance of the market salary and the minimum thresholds not necessarily being the same thing, but also some of those tips there, Agnes, about the Dharma and the Dharma threshold. So I think the key that I'm taking away here is that you saw the experience that we have in migration law, but the key factor there is to talk and work out what is the best pathway for you. But where we come in employment law is that quite often when we're working with migration, we're mindful of we're drafting an employment contract that's going to be scrutinised by the department. And what we're aiming to do is to make that process as seamless as possible. And essentially, we're looking to assure the department or the assessor, as they're going through, that we're meeting their requirements on what they're expecting. What we find quite often is that an employer will run on a contract that might be, say, 6-7 years old, or one that they've got from a mate down the road. And those contracts are lacking in the specific sort of details that the assessors are looking for. And that can cause you a great deal of problem, because if the assessor is not satisfied that the employee is being engaged on similar sort of requirements, or their fair work obligations are not being met, they may just outright reject your application. Sometimes they'll ask for clarification and give you a second bite. But if they don't give you that opportunity and you haven't ticked the box with your employment contract, all that hard work, all those issues that you went to can be thrown out the door simply because we didn't go to the step of ensuring that what you've got is what they're looking for. So I suppose we're looking at this from an essential clauses with respect to a migration application, but at the same time, if you're going to update your contracts, you may as well get an update to modern drafting employment law standards as well. But some of the key clauses that employers miss are having a suitable salary review clause. And that's really important in a sense where we have the ability to make changes. So you might have agreed with somebody a certain rate, but you can see now that if those contracts are out of date and they haven't got a situation where it's clear that those salaries are going to be reviewed or have the ability to be reviewed or changed, the assessor may sit there and say, you're running on a contract which clearly doesn't allow you to meet the requirements or doesn't allow you to reflect. You know, it might be a sense where the market testing comes slightly different from the TISMET, and they're saying you're $3 or $4 grand short. If you haven't got a suitable salary review clause in place, it may be difficult to say, oh, I've upped the salary. You know, they'll be saying we're just doing that simply to meet the requirement, where if we had a suitable clause in there to allow us to undertake salary reviews and reflect market rates, we can simply say, yes, we've done our research and we've increased our offer and here's a variation letter. It can be difficult to justify, though, if your contract's not appropriately worded. The other aspect is that employers often get it wrong where there's no clarity on what the remuneration involves. So where we've got situations where car allowances are included, or there's an annual salary and it's not clear whether it's exclusive or inclusive. And you heard the importance of, Agnes, that those rates are the rates plus superannuation. The easiest way for us to reflect or hit that assessment level is to reflect what the department is looking for. So we could obviously do an annual salary plus superannuation, which would be easy to tick the box, where a lot of employers have a practice of doing annual salary inclusive of superannuation, and you're asking the assessor to do some simple maths. So by simply reflecting the employment contract to be what migration, the department is looking for, we take away a lot of those other issues. There are also some pits and trapfalls that come up quite often. Quite often people sign a contract, it's got a commencement date, but the assessment takes a little bit longer to go through with migration, this contract should be starting from the date of the approval that comes through for the application. We don't want a situation where the contract starts on the date of signing, and we also don't want a situation where the visa conditions change or the visa expires and we still have an ongoing employment contract. So the right to work, but also the contract duration should reflect the visa requirements or the visa duration that they're on. And quite often we have a situation where people are saying, well, things have changed, or the visa conditions are no longer being met, or people leave. During that period, what are their obligations? What can I do with respect to what remedy can I seek? And I suppose that's another aspect that could be covered off now in your employment contract. But it's a fine line, Agnes, isn't it, with the compliance clause? So we can't have a situation where we're breaching the migration regulations, but we need to make it very clear to an employee that there are obligations that they owe to their employer during their employment contract. So setting out those obligations in an employment contract gets you off on the right foot from the start. You know, it could be an expectation that we've put you in this and there's an expectation that this contract will run for 2 years. And in the event that you leave prior to that, there may well be a consequence for that. It can also be a situation that there's certain obligations that they're to comply with, i.e. maintaining their visa requirements, maintaining that employment, maintaining full-time work. Those sorts of aspects are really important. Also, the character requirements need to be sort of pushed through quite strongly at this stage too, because quite often we're on a pathway. And to set those expectations in an employment contract is a very sensible thing to do. So it's not just your standard employment contract we're looking at here. There's some tweaks and some refinements that need to be made. I think the other aspect too that is really important here is that they're also assessing your employment contract against industrial legislation. So if you've got our old outdated clauses that reflect improper termination requirements, improper notices of termination, all those aspects can be sort of nitpicked by that assessor to say, are you employing them on the same terms as a normal Australian citizen? Or are you doing something that's not consistent with the requirements under any modern award, or not consistent with modern Australian employment practices? So there's nothing stopping us having a restraint, but the restraint needs to be a reasonable restraint, you know? So I suppose it's a key opportunity now to say, okay, my employment contract is just one of the documents we need to do, but it's one that's often overlooked and it's one that's hard to remedy if you're running on something that's out of date and you're saying that'll do, I meet all the requirements, but if it's that one sticking point, it's one that you should perhaps go and review at an early stage, I suppose, is what we're trying to reinforce here. I think the other thing too is that you could see today there was quite a lot of variability, like the differences in the exemptions. So you have a range of employment testing, but you also have a range of salaries, etc. So don't necessarily just sit there and say, here's the requirements. You should sit down and talk to your migration lawyer, your migration agent, and say, what is the pathway? What is the salary? What is the market rate? Do I have some variation? And then use that information to come back and say, now draft me a contract to reflect what I want.
May I just say something here, just for the interesting hint or observation what I have got recently. One of our visa applicant has presented pay slips, okay, with 40 hours as an employment, you know, like he was in employment full time, but it was 40 hours. Now, the base salary for an employee is 38 hours. Now, you can think how difficult is overcome of this discrepancy. Because if you get paid for 40 hours, the same amount of money that you had to pay for 38 hours, you are 2 hours every week below the TISMIT, what you needed to pay for your employee. Now, 52 times 2 hours is 104, right? Now, if it's 104 hours would be $5,000, just hypothetically, you underpaid your employee by $5,000.
And it's something, Agnes, it's something that could simply be overcome when we draft that employment contract to reflect the Fair Work Act, which is that your ordinary hours are 38 plus reasonable additional hours. And all it really is a situation is that we could have an annual salary that covers us for that, but simply because of a poorly drafted contract. And it's reflecting things back from work choices. So it's reflecting contracts back at 2008 and 2009 that haven't been updated, which simply could have been overcome by drafting your contract properly. Have no impact at all on necessarily the way we pay. But instead of, obviously, we would need to update your pay slips to reflect 38 being the annual salary. But we could still make them work 40 because you're allowed to. Exactly. But if you don't have that in a modern employment contract, bang, you've got that problem. Just like you're saying, it's very difficult to overcome if you haven't drafted it properly at the start.
Exactly.
Yeah. It's a great point, Agnes.
Yeah.
So can I go to the next slide? So I suppose we'll look at some of those key risks. So the common issues include is that we run on outdated TISMIT thresholds. So the issue here is, Agnes sort of indicated us to now, if we're looking to put somebody in and do an application now, our labour market testing really should be using the new TISMIT thresholds or the increased thresholds across the board. If we go and draft an employment contract, and we do that now because we're trying to secure the employee, but we don't reflect what the TISMIT should be, or we don't have a suitable salary review clause, we're off on the wrong foot already. So really the key here is to talk to your migration lawyer and then say, when do I use my employment contract and what is in that employment contract? And we just don't make silly mistakes simply because we don't put that attention to the employment contract. It's not the most important part of your migration application. It's one of many steps, but it's one that a lot of employers sort of overlook because we issue this contract. That's the one we use. It's not one we pay a lot of attention to, but it is important, particularly when you're doing it in a migration application, is just to take that extra step and say, okay, let's review it so we can streamline this process. The other one, and I think it's really important, Agnes gave you guys a bit of a tip about what happens in a situation where they're just below, and we realign their position and duties. However, if you can't justify why we've got that increased salary and we haven't got those sort of team leader duties encapsulated in on the position description, and normally that's Schedule 2 of an employment contract, and we can't justify why we've got that increased salary, you end up having an argument that you may or may not win. But if you've increased your position description and you've made clear why we're paying them above that rate and why we're meeting that requirement and what the extra obligations are, we can just point to the contract. It takes away a lot of the argument that you don't need to have if we review those suitable duties and position descriptions now in preparation, because we know we might be having that argument at a later stage. So I suppose I'm talking about the strategy. Yep. So it's not just updating your contracts for employment law's sake. It's updating your strategy to improve the success of your application. And I think the other aspect that we have to here is that sometimes employers can go too far. There are certain things in employment contracts that we do not want to see in that employment contract. Okay, so the issue there is if you don't get it reviewed and you don't get that advice from the migration lawyer, or you're not listening to that advice from the migration lawyer, you may well find that the applicant turns around and says that's above and beyond what's acceptable, or it's above and beyond what the requirements are for the migration regulations. There are certain things that as an employment lawyer, I can come to agreements, particularly on repayment of costs that we pay on behalf of an employee, not your costs, but the costs we pay on behalf of an employee. Those sorts of things can be done through agreement, but you don't necessarily want those sorts of private agreements being challenged by an assessor as to its appropriateness or not. There are certain things you can charge, certain things you can't, but I don't really want to be having an argument with a migration assessor down in Canberra when I could simply have it in a separate agreement. So, but they also need to be lawful. So I suppose that's another example now of sitting down and talking to your migration lawyer and in conjunction with your employment lawyer to get suitable agreements in place for what you want. These sorts of issues, though, can lead to a range of certain things. So if we don't set out what their sponsorship requirements are and what their obligations are, we're not setting out how we've calculated the salary, how those duties are, we can end up with situations where we end up with sponsorship cancellation. If we go too far in that employment contract, they can also challenge our suitability as a sponsor, can't they, Agnes? So if we don't comply with what our obligations are, we can face some penalties, some exclusion periods. It can just set the cat amongst the pigeons in many ways. And the other aspect we have is that we can end up with a situation where our next application becomes a little harder. You know, if we need to go and talk to the Chamber of Commerce on those sorts of applications, or get those sorts of approvals, or get those sorts of labour approvals, and we had an interaction that didn't go well simply because we had a poorly drafted employment contract, that can make our next application unnecessarily difficult. So it really is an important step at this stage to sit down and say, okay, I'm not going to run on my one pager that I got in 2008. I need something that's going to tick the department boxes, provide me protection, show the department that I know what I'm talking about, and show that I'm not really here for a debate because I already know what my requirements are, and it's easy for us to point them to exactly where that query is. Oh, show me how you've calculated it. Show me why this team leader role is a team leader role. Show me how they're meeting the Fair Work standards. Show me how we've got a suitable restraint but suitable notices of termination. You know, show me when the contract starts and when the contract ends. These sorts of things aren't often covered in the 1 or 2 pager that you pull off the internet. Yep. So it really is important. I can't stress it, that you take this step seriously. And once you've done it once, it's not hard for you then to do it again and make those changes. But we are finding that a lot of employers put it at the bottom of the pile, and they're looking to say, yes, I've got my documentation in order. I've pulled the contract from HR, but I haven't assessed these types of things. So it's probably a key time too, particularly if a lot of you are trying to meet that July time frame, or a lot of you are saying, okay, well, where am I going? I'm looking to move forward and push on with these applications. Pull out your contract and have a look to say, okay, is this going to meet what we've spoken about today? And is this going to assist me with my migration application or hinder me? Because it's not a difficult job for us to change it, but it can be a bit difficult if we're trying to change something after we've lodged, or to convince an assessor, oh, it doesn't mean that, it means this. So just get your house in order.
Yeah.
I think I'm starting to repeat myself a bit, Agnes, but you can see it's not the most important part, but Agnes has brought me in because it's one of those issues that we want to try and get you to try and streamline these processes. We want to try and knock it off now, so we're not having these discussions at the 11th hour before we lodge. We're running around trying to get contracts signed. So just put it on your checklist of one of those things to look at whilst you're talking to your migration agent. And that's essentially it for me. Agnes, next slide, please, if I could, Mel. So I suppose the things to go and look at from the checklist from your employment: does your salary meet the new requirements? If not, is there something you can do? So talk to your lawyer. Do I have some flexibility? You saw the expertise that Agnes has. Her team relies on Agnes, trained by Agnes. They have these skills to sort of blend it in. Just don't presume that you're outside the range. There quite possibly is something that can be done, but also don't also presume that that your minimum standard is going to be the rate. You need to talk about market testing as well. Look at your job descriptions, and then also liaise with your job descriptions to make sure that it can be justified by the salary that we're paying. Agnes gave you a prime example of running on an old contract and the problems it caused. Make sure that your contracts reflect modern requirements under the Fair Work Act and modern drafting standards. Are the hours, the location? Is the location consistent with what the application says? If we're doing a regional application and we've got the location based in Brisbane, we may have a problem. You know, they might work sometimes in Brisbane, but it's how we draft that in the employment contract that's a key. Are our termination provisions compliant? You know, a lot of the time we've got to have a termination provision that reflects the minimum requirements in the Fair Work Act. And more importantly too, what rights do we have to be able to alter and review our salary? And have we made clear how we've calculated our salary? So simple things, just clearly that, is that annual salary plus superannuation, or is it inclusive of salary? Inclusive of superannuation could be an issue. Where we're referring to car allowances payments, how do we show what the actual salary is that the assessor is looking for? So having a look at how we've expressed that salary is really important for the purposes of the application you're about to lodge. Correct. So there's sort of the key checklist, but I'll hand back to Agnes and I'll let her summarise for you.
Yeah, thank you very much, Darren. I think, you shed some lights on some of the key aspects of the employment contract, which that's not my expertise, but, I can always guide the client, hey, we need to have this included, or we need. And just on that note, actually, and you raised a very important question, car allowance or any other contribution is not forming part of the base salary. So any additional payment to the visa applicants in the nomination has to be reflected separate, but the base salary has to be the 73 or the 76,000 and whatever $150. So that is very, very important. All right. So anybody has any question?
Yes, please.
Yes, please. Go for it.
Hi, Darren and Agnes. How are you guys? Agnes, you raised a good question about that 40 hours and 38 hours reflected on payslip. And Darren, here as an employment specialist, there, if the minimum, if the salary in the contracted salary does cover above the threshold, that can be, my understanding, does that cover or offset any additional hours between the 38 and the 40?
Yes, absolutely.
Work or reflected on the payslip?
Absolutely. That's my understanding. Darren?
Yes, it does, Tony. So we just do the annualised salary clause, which includes all penalties, loadings, etc. Petty load, overtime and allowances. But we need to have that annualised salary clause or an equitable set-off clause carefully drafted in the employment contract, which you do have, Tony, I know from experience. But the key there is that, and it sort of flows into Penny's question in the chat as well. The key there, though, is that the salary. If an assessor then turns out and says, okay, you're paying an annualised salary, but I can see on the pay slips here that they're regular working 50 hours, we need to show that we're not falling below the modern award requirements. It's not likely to happen that often, though, because the annualised salary and the levels are at such a level, they tend to be fairly the immigration requirements are above the modern award requirements. The risk is just where they're working excessive overtime. But, we do have a substantial buffer. But in those sorts of situations, it's only really where the award rate is close to the annualised salary rate where you might be challenged. But again, we would just, if you've got that suitable equitable set-off clause or a properly drafted annualised salary clause, it's not really a situation where you would expect there to be much debate with the department.
Now that will take me to my second question. In your views and advice, what does the Department of Immigration wants to see in an employment agreement, which is part of the application? Do they want to see 38 hours agreement or 48 hours, 40 hours agreement? And on the other side, what's the Fair Work wants to see in a sponsorship application employment agreement, 38 or 40 hours?
They're both consistent, Tony. The law says that ordinary hours are limited to 38 hours in the Fair Work Act. So if you go and put ordinary hours at 40 hours, you're actually in breach of the Fair Work Act. So what you put in the employment contract, and it's just a matter of of how it's drafted, is that their ordinary hours are 38 hours plus reasonable additional hours. You're allowed to say that.
Regardless, whatever the salary is.
Yeah, but then the salary then needs to say that the salary is set at a level where it's covering them for all penalties, loadings, overtime, and allowances. But but the salary also needs to be set to reflect the hours that they're doing. So it's not, the department wants to see that it's not in breach of the Fair Work Act. But again, it's coming down to having appropriately worded and modern drafting practices in an employment contract. And the simple fact that people still have 40 hours is because that's what used to be reflected in work choices. So they're running off a outdated contract and they just haven't updated it. But it's a red flag to the department. And well, what other practices aren't up to date, Tony?
Okay. Thank you very much.
And Tony, also just on that note, because the employer has done everything correctly, it was the oversight of the accountant who was an outsourced accountant, right? And he wouldn't needed to put on 40 hours, but based on a pay slip, how that is drafted, he needed to put something there, and he put the old hours there. So we just need to be so mindful of this. Is very important when you have an employee who would like to transit to a permanent residency, and they need to provide these documents. And immigration can argue, oh, this is 40 hours. And another very important thing is, under migration law, the full-time employment can vary between 35 to 40 hours, okay? But the salary, if you offer someone 35 hours, the salary must be $73,000 or $76,000, okay? And
that's the threshold.
That's the threshold, an absolute minimum threshold. Someone can work part-time if you have such an awesome guy who is a salesperson, and the salesperson can achieve, the monthly target in 3 weeks. It doesn't matter, he doesn't work another week, okay? But the salary still has to be the minimum threshold. And also, I think what Darren has not mentioned, because we're working together, when you have a salesperson, say we have a lot of clients, who are employed as a technical salesperson or as a sales promotion officer, and they are on a base salary and meeting the KPI, and they receiving, bonus payments. So the bonus payments should not be in the employment contract. It should be a separate agreement or a separate document, because you cannot vary the employment contract, based on their performance, okay? So these are all the very important aspects to do the writing for migration, writing under industrial law, and writing for the business. Hey, we are all in business. We need to look at what is the good thing for the business, right? And the most important thing is under migration law that the minimum salary, what we agreed on and what it's in the application, has been paid to the employee. Okay?
Yeah.
Thank you very much. You've ignited that 40-hour things, and I'll revisit now all the payslips we generate.
I'm sorry, Tony. No. I didn't mean to do that to you, okay? But
all good, all good.
And I think the key here is to talk to your migration lawyer, rely upon their experience, and then make sure you then go and draft the employment contract to meet the needs of what you need to get a successful application across. Don't put the employment contract in place before you talk to your migration agent or your migration lawyer. Talk to the experts, and then adjust what you need to offer with a view to where you're going. It's always more difficult to change something after the fact. So use that expert advice. You can see that they're experts, but don't rely on a piece of paper that's going to cause you grief unnecessarily. But there may be certain things that need to be tweaked. So you might have a certain way you want to pay, and you say, I've got the bonus policy, I've got the car allowance, I've got a range of different things I'm paying in there. But certain things need to be in the contract and certain things don't. And it'll be different for different people, but use their experience and then just say, okay, I'm going to make sure I take that step to get updated.
Yeah. Tony, have you answered your questions?
Absolutely. Thank you very much.
You're very welcome. Has anybody else has some questions who are still participating? Mao?
I think we're all good.
Okay, then we close the meeting, and thank you so much. You know, I will follow up with the email, and I thank you so much for attending, and have an amazing afternoon. And good luck with your nomination.
Thank you. Likewise to everyone.
Thank you. Bye, everybody.
Bye.